So, welcome to this month's Lunch and Learn webinar on top mistakes in special needs planning. Today's presenter is Michelle Fuller. She's the owner of Michigan Law Center and president of Advocacy Inc., which is a nonprofit organization that administers special needs and settlement trusts. She's been practicing special needs planning for 25 years now. She's a published author and the 2018 recipient of the Unsung Hero Award given by the State Bar of Michigan. In just some housekeeping, Michelle is going to be taking questions throughout the presentation. So you can use the Q&A function at the bottom of your screen to leave your questions as they arise. And this is being recorded and will be uploaded to our YouTube channel and our website once it's edited. So you can look out for that in a week or so. I will email all of you. So with that being said, Michelle, you can take it away.
All right. Thanks, Maddie. Appreciate it. So we're going to be talking about just the most common mistakes that I see in special needs planning. We're very, very fortunate that our firm really exclusively works with people with disabilities to do planning, both on when they're receiving money directly, which is usually an unplanned for inheritance or a lawsuit recovery. And so those are our people. And so if you're looking at this webinar, looking for information, this is part of our continuing series. And so if you have ideas or other topics that you would like to see explored, please leave that in the comments or email the firm or just give us a call and just reach out, because we would love to know what else that you would like to hear about. And so this morning, we're going to really talking about a very basic overall big picture view of special needs planning. And what are, again, some of the top mistakes that I see happening in the just overall. So what we're going to cover is the primary purpose of a special needs trust. And yes, the primary purpose of any special needs trust is, of course, public benefit preservation. But that is not the whole story. And I think that the secondary purpose, you see, there's the three main bullet points there on this slide. And I think that overall, increasing the person's independence and quality of life is of greater purpose than just preserving public benefit access. And so the secondary purposes, I think, are just as important. One is there's greater protections in a special needs trust. You get professional investment of the assets and additional caregiving, as well as, just advocacy, overall benefits, looking and seeing what other resources we can create where it's a blend of private and public dollars to, enhance that individual's life. First, what is a special needs trust? So you might wonder, where you have a trust in place, sometimes they're called different things. Lawyers tend to name things different ways. There's no right or wrong. Apparently on the East Coast, special needs trusts are sometimes called bubblegum trusts. I've seen them called amenities trusts, sometimes supplemental needs trusts or special needs trust. The purpose is all the same, which is to provide additional guidance and, of course, preserve any kind of public benefit access that people need. And so I don't really care what it's called, other than it should be easy for a government agency who's reviewing this trust to identify what kind of trust it is and what it's supposed to do. And so that's why I don't like things like a bubblegum trust or an amenities trust, because I think it's misleading and it's unclear both to any government agency or court that's reviewing the trust. And it's certainly unclear to anybody who is supposed to be administering this trust. So to me, this is not a time to get fancy or creative on the naming of it. And so, the primary purpose of a special needs trust is to create access to public benefits, and that could be a means-tested public benefit. So there's a lot to unpack there. That means any benefit that has either an income limit or an asset limit to be eligible for that benefit. And we're really talking about SSI or Medicaid. And Medicaid is a huge umbrella, and there are so many different programs under Medicaid that, and they all have different requirements. Some have both an income limit and an asset limit. And I think that if you're looking at this video, you're probably very familiar with the $2,000 asset limit. Michigan just increased that limit, but unless you're an SSI recipient. So this is, as you can tell, this is a very complicated area, and there's a lot of overlap and a lot of complexity between these government benefit resource requirements and different programs. And so the idea of a special needs trust is that it allows someone to set aside money and still have eligibility and have access to those resources. One of the other huge purposes is to be able to create an administrative framework for somebody who has special needs so that they have some professional guidance. A lot of times these trusts can be, relatively modest, all the way up to something that's incredibly complicated with tens of millions of dollars in it. And I don't know about you, but anybody who's got that kind of management or that kind of portfolio certainly needs additional resources like tax planning, not just, probate or trust in estates, but, professional financial management. The more money under management, the bigger the team of professionals should be. The other thing is it also really helps protect against predators, creditors, just outside people with their hand out, right? And what we call the lottery effect, where how many people, success stories do you see where people have won the lottery and it's made a huge difference to their own lives and the community, right? We tend to see disasters where the money actually makes their life worse. So we try and prevent that as well. So the number one question that I have when a family or an individual comes to me and they think like, oh, I think I need a special needs trust, or I'm really concerned that I'm getting this money somehow, and how am I not going to lose my benefits? Okay. And so the first question I ask is, whose money is it? Is it money that's been left to you in your name, like through a life insurance policy? That's to you as an individual. Okay. Maybe a will or a trust leaves things directly to you. Okay, that's a different type of resource. Or is it where you're getting a lawsuit recovery? Right? And so we always ask, whose money is it? Is it fundraised money? That's from like a GoFundMe or a community fundraising event. Where did the money come from? Right? And so that determines what type of special needs trust that we use. And there's different types. So there's two main types, depending on the answer to that question. First party and third party. You're like, oh, that sounds like a bunch of legalese. Well, yeah, it is. It's exactly what it is. And so where we see the difference, like what's a first party versus a third party? Well, it comes from contract language. Party the first part versus party the third part. Party the first part means it's your own money. It was left to you or you owned it before your injury, accident, or illness that rendered you disabled. And so that's a first party trust. If the money is yours, left to you directly in your name, then it is your money, first party trust. If it was someone else's money, mom or dad, grandma, sibling, somebody who's leaving you money, and they're doing it through a trust, like through a special needs trust, or there's language in there about making sure that you don't lose your public benefits, well, then that's a third party money that's coming from someone else, some other family member, a friend, community fundraising, that kind of thing. And so that determines first party versus third party. So let's talk about a third party trust and what that means and what that entails. A third party special needs trust can be established or created by anyone other than the individual themselves, the individual with disabilities or that needs protection. And that includes their spouse. And you think, well, why does that include their spouse? That's not necessarily a person with disabilities. It's a separate human being. Absolutely. But when you think about a married couple, how do they file their taxes? Right? Usually married couples file jointly. And that the reason for that is that a government agency, the government in and of itself, views a married couple as one entity, one taxable entity. And they also include that when it looks at benefit eligibility for any of these resources that we're talking about. They always include anyone who has an obligation of support. And for an adult, that means their spouse. That spouse has an obligation of support. So that's when they look at that. And so that's why their spouse cannot create one of these trusts for a person with disabilities for that very reason. And it must be funded. So we've got the creation part. It can be funded by anyone else, anyone on the planet other than the person themselves with disabilities or their spouse. So, okay, now you've created this trust. They can sign as grantor, right? Meaning they can create the trust. Fine. What do you put in it? You can put anything in it that doesn't belong to the beneficiary or their spouse. It has to come from somewhere else. So again, this is where I, like community fundraising, fine. Any other relative, usually mom or dad. So this is an estate planning mechanism. And so what are the requirements? Very simple. There's only 3. That the person who created the trust is someone other than the beneficiary or the spouse. It doesn't hold, the trust itself does not hold any assets that belong to the beneficiary. Okay. And the beneficiary cannot own or control this money or any of the assets in the trust. That's it. So meaning they can't demand payments, they can't demand income, and those 3 requirements. So can you create a legally sufficient third-party special needs trust in a couple of sentences? Yes, you can. And that might be surprising to you. But legally sufficient in terms, when we were in school, you think, okay, what's a passing grade? A passing grade is a D+, or like C-, D+. And that's kind of the quality of what we're talking about, is that yes, it's legally sufficient. It meets the bare bones criteria, but nothing else. Okay, so that's about what I would give it, is about a D+ or a C-. So what's really, really important here is that for practitioners, or even if you're an attorney and you're looking at this, or if you're reviewing your own trust, this is a very common mistake that I see for inexperienced practitioners that are drafting these. There is no Medicaid payback. So the beauty of this, and why it's so imperative that family members do proper planning for people with disabilities in their lives that they want to leave money to, is that at the end of the beneficiary's life, the money that remains, if there's any money, goes wherever the grantor, whoever's setting this trust up, it goes wherever they say it should go. There's no payback. And you'll see why this is so important when we discuss first-party special needs trusts. So that's when it belongs to the person with beneficiary, individually. So a third-party special needs trust can also be set up for more than one person. So sometimes families have more than one person with disabilities that they want to benefit. And this third-party special needs trust can be designed for more than one person, as long as the estate planning objectives, like where the money goes afterwards, after the beneficiaries have died, as long as there's no disagreement as to where that money should go, then it can benefit more than one person. With a first-party special needs trust, that is money that belongs to the individual. And this is where do we see this? Really 3 circumstances. One is where the person became disabled later in life, and they already had assets. And it might surprise you to know 1 in 6 people in the United States have disabilities. But just because you have disabilities doesn't mean that you meet the Social Security definition of disability. So what is that? What do I mean by that? So I'm an attorney, right? And I use my hands, I use my brain. And if I lost my left leg for some reason, does that mean I couldn't practice law the way I do now? No, it doesn't. And so I would have disabilities, but I wouldn't meet the Social Security definition of disability. So to be entitled to use a first-party special needs trust, you have to meet the Social Security definition of disability, where your disabilities, whether they're physical or mental, have to last longer than 12 months or result in death, and it has to impair your ability to work. Okay? And so, that's the adult definition. There's a slightly different definition of disability for Social Security if you're a child. And so what's a first-party special needs trust? What are the elements? One is that, again, you have to meet that Social Security definition of disability. The trust itself must be irrevocable. So irrevocable doesn't mean you can't change it. It just means you can't say, I revoke it. I don't want this anymore. I'm done. I just want my money. You can't do that. not without some consequences. So it must be established. So here, in contrast to the third-party special needs trust, here it can be established by the person with disabilities themselves, their parent, their grandparent, their guardian, or the court. And so it's very important that how it's established, it should be established properly. It has to be for the sole benefit of the beneficiary. The rules around this have loosened up quite a bit. There's something that we refer to called the POMS, Program Operation Manual Systems. And that's the Social Security guidelines, administrative policies on these trusts. And so that's the rule book that we refer to as practitioners, as well as Social Security workers themselves. That is their Bible, their guidebook on how these trusts are evaluated. And so this is really, really key. For a valid first-party special needs trust under the code section, D4A code section, so these trusts are often called first-party special needs trusts. They're called D4A trusts. Sometimes they're called payback trusts. In order to be a validly executed trust, a valid trust, the beneficiary must be under the age 65. And it can't really be funded after age 65 unless you meet certain exceptions. So it's usually a stream of income that started before their age 65. So it could be a structured settlement annuity that starts before the person is 65. It could also be spousal support that starts before age 65. There's very few exceptions to that rule, but those are things that are laid out in those POMs. And so most importantly, something to pay attention to is that upon the death of the beneficiary, there's an actual obligation of the trustee of this trust to reach out to all of the states where the beneficiary has received Medicaid benefits. And those states get paid back with any remaining assets, even if it means that there's nothing left. And so this is not a situation under these first-party special needs trusts. Remember, this is a huge contrast between the third-party special needs trust and a first-party special needs trust. On the third-party special needs trust, there's no obligation to pay the states back. On a first-party special needs trust, there's an actual obligation of the trustee to reach out to the states where the beneficiary has accepted Medicaid benefits and pay them back out of any remaining assets. After the states have been paid back, only then do family members are they able to receive any money. And it's not just family members, it could be whatever the beneficiary's wishes are. That's only when they are honored. And so this isn't a situation where a trustee can just sit back and go, well, they haven't reached out. They have to make a claim. It's the trustee must reach out to the states and let them know that, hey, you need to assert your right of reimbursement here. Here we're getting into the top mistakes, which is confusing public benefit programs. So we just kind of glanced over this in the very beginning where we talked about like Social Security, the POMs, and Medicaid, and there's all kinds of different Medicaid programs. And so there's different types of public benefits. There's two main buckets of resources. One is a needs-based program. So we also call those means-tested. And that means that there's usually a medical component, some sort of medical qualification to qualify for these benefits. But then there's also a financial component where there's either limits to access based on income or remaining, like what we call them, resources or assets, things that you own. And yes, that includes cash under the mattress in order to qualify for benefits. Sometimes there's only an income component. Sometimes there's income and resource limits as well on top of the Medicaid, the medical qualification. And so needs-based public benefits, again, means-tested public benefits, and those vary widely, like among states. Why? Well, Social Security is federal. So the Social Security rules around access are the same across the country. The difference is the Medicaid component. Medicaid is a federal benefit that is administered by the states. And each state has rules an agreement, basically a contract with the federal government that outlines how each state is going to administer those federal dollars. And so they have different programs. There's different ways of access. Similar programs exist among the states, but sometimes they're called different things. And so there's different types of Medicaid buckets, right? That covers everything from general health insurance that might be under the ACA or Affordable Care Act. It might be for children. It might be in-home supportive care. It might be nursing home care. It might be access to specialists. There's all kinds of different Medicaid programs. In contrast, entitlement public benefits are, there's a lot of social media about the word entitlement, but the idea is that you've paid into the system, whether it's Social Security, it's usually Social Security, so that if you've paid into Social Security, you are entitled to get benefits as a result. And those benefits are not means tested. So you can't lose them. If you win the lottery or get a giant inheritance, you cannot lose SSD or Social Security disability or retirement Social Security because of a change in circumstances. Okay. The exception to Social Security disability is that you can lose that benefit if you go back to work full time. Right? So it has to do with work. It has nothing to do, though, with financial eligibility. And so that's really, really important. So again, just to be completely more complication, can you get all of those benefits? Can you get both entitlement public benefits and means tested public benefits? Yes, you can. You can get a full suite. If your entitlement SSD benefit is kind of low, you can get supplemental security income to help bridge a gap to get to a minimum income level. And so, as Justice Powell stated, the Social Security Act is among the most intricate ever crafted by Congress. Its Byzantine construction makes the act almost unintelligible to the uninitiated. And so I have to tell you that sometimes you have to out-stubborn the system. And we've seen a lot of shakeup in Social Security and government agencies post-COVID. And now, there's even more shakeup. And so as information becomes available, we will be doing some webinars on that or some YouTube. And no, I don't know what's happening other than I just follow the news. And so as information becomes available, we'll certainly do additional YouTube videos on what's happening or our best guess. So here's the next top mistake that I see. Confusing the different types of special needs trusts, right? So we've talked about first party versus third party, the different types of special needs trusts. It can be very confusing. Even to other lawyers, I talk about this with other, when I'm teaching to other attorneys or even judges that don't see this every day, it can be very confusing. And so this is where, again, we try and keep it simple. Whose money is it? If it belongs to the individual with disabilities, then it's a first party trust. If it belongs to anyone else, mom, dad, sibling, aunt, uncle, fundraising, crowdfunding events, third party SNT, because it belonged to someone else. And so there's different types of first party and third party special needs trusts. So let's talk for just a minute about first party special needs trusts. And so this is created under a federal law called the Omnibus Reconciliation Act of 1993. Yes. So I don't know the names of a lot of acts, but that is one that I know because we work in it every single day. And so there's an A, a B, and a C trust, a D4A, a D4B, and a D4C. That's outlined within that statute. And the whole purpose was that Congress recognized that just living on means-tested public benefits is not enough to meet all the needs an individual has. And so the Social Security or supplemental security income and Medicaid was really designed to only take care of those basic needs. Basic need for shelter and a basic need for healthcare. And so a D4A special needs trust or a payback special needs trust we talked about, and you must be under age 65. You have the ability or the beneficiary can create it themselves. And it is really designed for someone who has a lot of choice. That is typically a custom drafted trust And the beneficiary or their loved ones who are helping them with this planning can nominate whoever they want to serve as trustee. A pooled special needs trust, we're also referred to as a pooled trust or a D4C trust. Again, the money, you must be disabled. The money must belong to the individual has disabilities. But it's not necessarily for people only under age 65. And so different states have different rules about whether they accept over age 65 contributions to a pooled special needs trust. But where a D4A trust is really designed for one person and it's custom drafted for that individual, a D4C trust or a pooled special needs trust is really one master trust agreement that's designed to administer funds for a group of people. Anyone who has disabilities is eligible to have their funds administered under those terms. So the trust is, we call it a pooled trust because people's funds are pooled together for purposes of investment. And so I like to use pooled trust. We can talk for days about the uses of a pooled trust and different types of things, depending on the situation. But I personally will recommend a pooled special needs trust for an individual who has assets that need protecting at less than, say, $350,000. Why? Because that, for me and in my practice, is typically the break point, where if you have more than that, you really, really should have investments that are planned and specific to you and your needs. Less than that, I think there's a greater benefit to be part of that pooled investment strategy, where you have access, where you have a big pot of money. You can get more and have a better return on investment by pooling your money with others. It also usually costs less. So pooled trusts are administered by nonprofits. And so your mileage may vary. You have to be a good consumer. And this is where a skilled special needs planning attorney will help be able to determine what the best fit might be for you and your particular needs. Miller trusts are accepted in states, not in Michigan, but in states like Florida, where they have income caps. So if, for instance, you need to qualify for certain public benefits, like a Medicaid benefit that has an income cap, and your Social Security is over that income cap, Miller trusts or D4B pooled trusts help you to gain access, even though you're over the income limit. So Florida is one of those states that does allow for that. Third-party special needs trusts can be a custom trust for an individual or a small number of people. And those are custom drafted. And to me, same thing. Like if you may have a house and at least several $100,000, I think that the alternative, and to me, the best case scenario for planning would be using a pooled third-party special needs trust. And so, again, it's administered by a nonprofit, and to me, it's a really good alternative to an expensive custom drafted trust. And so actually, Kevin Urbach and I co-authored an article several years ago about using a third-party pooled special needs trust, and it was geared toward practitioners, but that it was published by the American Bar Association, and that article is on our website if you want more information about that. Top mistake number 8. Improper planning, defective planning or drafting, or using a set it, and forget it type of plan where you did it once more than 5 years ago, more than 10 years ago, more than 15 years ago, and you haven't looked at it, and your estate plan is just gathering dust on the shelf somewhere. And so these are the top mistakes that I see. And so if you're a consumer or even an attorney watching this, what should you be looking for? Well, if you have a trust within a trust, I don't mind a special needs trust within a revocable living trust that is a safety net, where there's no known disabilities. This is just in case type of thing. That's fine. But if you are planning and you're dealing with an estate planner who does these once or twice a year, is that enough? Do they have the expertise that you are looking for to plan for a person who has a known disability? Well, one of the first tells that I look at is a trust within a trust. If you have somebody who you know has disabilities and they have basically what's called a subtrust within a revocable living trust, I think you need somebody that has more expertise. And so I don't love those for a variety of reasons, and we can go into that. That could be an hour in and of itself. The other huge mistake is including a payback element to the state Medicaid agencies when it is not required. And so again, in estate planning documents, I have seen that, and that is a huge no-no. You don't want to do that. The other is that where we see one-dimensional planning. In other words, the third-party special needs trust is really just designed to preserve public benefits and nothing more. And you'll see that in different types of distribution schemes or distribution standards, meaning that you cannot infringe on any of the public benefits. You can't reduce any of the public benefits. So you see that sometimes it's default language in some of our drafting programs that attorneys use. There's nothing wrong with using a drafting plan. I mean, most attorneys that do estate planning at any kind of volume do utilize a drafting system. The thing is, you have to be able to customize for what's appropriate for and the objective of the client. And so, again, this is kind of like that D plus drafting level where it's a small little paragraph, 3 sentences that is legally sufficient, but really doesn't help take care of the individual. So top mistake number 7 would be a poorly planned management team within special needs trust planning. And so we like to create what we call like the gold standard, where now, again, this is not with a pooled trust. To be clear, this is with a custom drafted trust. This is where you have the ability to really create an administrative checks and balance structure because most of these take place outside of, or take place, meaning these trusts are administered outside of a probate court oversight system. They are designed for that. And so because of that, we really need to make sure that there are appropriate checks and balances so that, one, that there's some support for the professionals involved, and hopefully there are some professionals involved. And so we'll talk about each of these different roles that people play. And of course, the more money, the more administrative structure there should be. Okay, so one, the trustee, I'm not going to hide my bias here. I think that family members generally, there are exceptions, but generally they have already so many jobs, they really should not be trustees of this type of trust. I did write a book called Administering the Michigan Special Needs Trust, and it is about 450 pages long. Is that everything a trustee needs to know? No, that is baseline knowledge that every trustee of a special needs trust needs to know. It's a lot. And so I generally prefer a professional trustee administer these funds. So whether there's a bank, a private professional fiduciary, an independent person, some professional that has the highest standards of ethics and obligations to that beneficiary. And so I like having banks or professionals, nonprofits, some professional organization act as trustee. Family members are free, but you kind of get what you pay for. And so I have successfully worked with trustees, but they are generally people who have the time and capacity to really dig into this and love working with rules. There are people out there that love doing that. And so they can make good trustees. But generally, my advice is to work with a professional. There is a great and a very important role for family to play, and I prefer them to be on a trust advisory committee. It could be a committee of one. It's fine. They just have to be able to act, I think, as like a super trustee. They hold that professional trustee accountable. Again, these typically take place outside of a court system, and so they take the place of the court to make sure that the trust is running well, that the beneficiary is well supported by the trustee. They can also act as kind of a buffer under certain circumstances where the trustee has to make difficult decisions and they're looking for guidance from the people who know the beneficiary the best. And so that's where a trust advisory committee can be incredibly important. I typically, where we have a professional trustee, I also kind of build in that superpower where they're not, or the trust advisory committee is not responsible in any way for the day-to-day administration, but they do have an important authority, which is to hire and fire the trustee, no questions asked. So I think that really, again, it's all about checks and balances, right? The trust protector is typically the law firm who drafts the trust. Why? Because again, this takes place outside of a court system, and the trust protector is allowed to make amendments to that irrevocable trust. That is really important because it keeps you out of the probate court. So when you have an irrevocable trust without that mechanism, you're back in court to make any amendment to the trust. And that includes changing trustees, making modifications for Social Security, changes in policy, changes in the tax code, anything that impacts the integrity of the trust to meet and fulfill its purpose. And so anytime you're going to probate court is incredibly expensive. And so by expensive, I mean, typically I would save anywhere from $5,000 to $10,000. So you want to avoid that, and you want to be able to react very quickly. And so this is that mechanism that's built in. A trust director can also be built in as a significant and carve out. So you may have trustees that have different roles and duties. So you may have an investment trustee, you may have an administration or distribution trustee. So this is very custom depending on the individual's needs. And the more complex the situation, the larger the amount of money that we're dealing with, the more of these roles we have to create. Again, this is all about checks and balances so that the beneficiary is well protected. And so certainly an investment advisor, I'm president of advocacy that actually administers these trusts. And an investment advisor, the choice of investment advisor and tax professional is really, really important here, where you don't, somebody who's adept and skilled at planning for retirement is not necessarily going to do a good job here. Planning for someone who is retired essentially at age 30 and you're trying to make the trust assets last the rest of their lives, how do you do that? Well, you have to have a professional who has the background and experience in administering these funds. And so there's really great financial advisors out there, and we of course have our favorites, but they should be well vetted. Top mistake number 6, which is failing to reform defective trusts. So this is something that I see quite frequently that is missed, where people think that they're stuck. So this is very state specific. And so what you'll see here is a reference to Michigan compiled laws. So if you're looking at this and you're not in the state of Michigan, this is very, very state specific. And so can we reform a defective trust? So let's say that someone is receiving benefits and has disabilities, and they are receiving an inheritance through a trust or a will that talks about this individual and somehow some reference to the fact that they have disabilities. We can go in our court system, in the probate court, and reform that trust. And that is really important. Remember how we talked about the difference between a first-party trust and a third-party trust, and that a first-party trust requires a Medicaid payback. A third-party trust does not. And so this is where if someone is inheriting money and the trust is defective, depending on the language in the trust, can we change and modify that trust even after death? Yes, it is possible. And so it's very fact specific, but our firm and other firms have done this very successfully, and preserving that third-party classification of the money, where, remember we asked whose money is it? And it's whoever the relative is that passed away, usually mom or dad or grandma, grandpa, aunt, uncle, sibling. Just remember the money has to come from someone else. And this is a really great and I think underutilized way to preserve that. And so I think there has to be enough money there to warrant going to court to make a revision. And again, it's fact specific, but a skilled attorney who has this in their background will be able to properly evaluate that opportunity and if it exists. And if it exists and it makes sense financially for the individual, then I think it's worth it. So next is not understanding the options. This is another huge mistake that I see where what is the payback provision in a first party special needs trust? Well, you have to look at the state lien documentation. So a first party special needs trust like that D4A trust, somebody passes away. And now, what is a trustee supposed to do? Well, you have to communicate with the state. There's usually a division within the state government that talks about these liens that is used to compiling that information. So when you get the information back from the state, it can be short, just depending on the person's how much they've used Medicaid benefits, but sometimes it's literally inches thick. As a professional trustee, I can't really review that and properly evaluate to see if all of the entries actually pertain to the beneficiary. Those things are there's always mistakes in them. And the family members will say, well, you weren't in the hospital. This beneficiary wasn't in the hospital at this time. Why is this on there? Yeah. And so there's opportunities to really review that and make sure that any errors are highlighted and deducted. Otherwise, states aren't really negotiating these. They're not negotiating these liens down. So if to the extent that there's money left, the states want to be paid back. This is a priority under the SSI program where there has to be reasonable fees for the administration of the trust. You can bill for wrapping up the affairs of the trust, but the state Medicaid agencies look at this very carefully. So when there's funds left, what happens? Who has priority, right? So let's say that there's a lien of $150,000 that the state has paid on behalf of this individual, and the remaining money in the trust is $100,000. So what comes out first? Well, first, reasonable fees for the administration of the fund, wrapping up the affairs of the trust. It could be getting a final accounting allowed. State and federal taxes, any kind of taxes that have to be paid, depending on the type of trust, those come out first. This is a big deal. So this is on first party special needs trusts only. In Michigan, you cannot pay for funerals. The state gets paid back first. So again, this is state specific because what are we dealing with? We're dealing with state Medicaid agencies, and different states have different interpretations and policies on how they administer this. If you are administering one of these trusts and you would like to pay for their funeral, you have to get permission of the state Medicaid agency first, especially if there's not going to be any funds left over after the state has been paid back to pay for the funeral. So the best policy is get a prepaid funeral. And this is really only for first party special needs trust, whether it's a pooled trust or a D4A trust. Not so much in California, though. The state Medicaid agency in California specifically says, no, we want you to pay for a funeral. And that's fine, even after death. Michigan, not so much. Top mistake number 4, poor administration of these trusts. I see it all the time. And my husband and I, Kevin Urbach, wrote an article called Traps for the Unwary. And this was published in Estates and Trusts magazine several years ago, but the traps still hold true. And so we see this typically with family member trustees where they don't read the trust document. It's boring. They are not meant to tell a story. These are legal documents, and they can be really boring and complicated. And so trustees, especially lay trustees, they don't want to read the document. And I get that, but it's really essential, and it contributes to a poor administration. Trustees if they don't have a system for setting up disbursements where they have excellent record keeping and there is an invoice or a doctor's bill or some sort of invoice that matches every disbursement, they can cause huge problems with Social Security Medicaid qualification, following the POMs, following the primary benefit rule. So we see this either being interpreted by trustees as being overly restrictive, or they don't follow it at all, and they just pay for whatever they feel is right. Distributing cash to a beneficiary on public benefits absolute no-no. There's other ways that trustees can use to allow a beneficiary access to funds. And that is laid out in our administration book, and it's too much to go through here. But we also have other, if you are a family member acting as trustee of one of these trusts, there are resources available to you. One is administration, the book itself, but also Kevin Urbach and I created what's called Moving to Mastery. And there are some of the top professionals in the nation who are talking about how to properly administer these special needs trusts. And that is available on our website, movingtomastery.com. These are also huge no-nos, is commingling first-party money with third-party money. You don't want to commingle Social Security money or any money that the actual beneficiary owns or manages or first party and somehow commingle that with a third-party special needs trust funds. I see that a lot, and it is deadly. You don't want to do that. It's it's a poison where it taints the entire trust. So you don't want to do that. This is huge, failing to maintain good records. That's a huge, huge issue. And not utilizing the tools that are available, such as an ABLE account or TrueLink, to be able to allow that beneficiary some agency, because that is one of the biggest complaints that we have with these trusts. Because remember, the beneficiary with disabilities cannot own or control this money. And so how do they get access to their funds? Well, we use the tools that are available, which is a TrueLink account, ABLE accounts. Those are incredibly powerful tools to allow somebody with disabilities to have agency and empowerment to make decisions with some safeguards. Number 3 is the trustee doesn't understand ISM rules, in-kind support and maintenance rules. In other words, they don't understand the public benefits rules, Social Security regulations, policies, and sometimes the courts can even misinterpret the purpose of a special needs trust where it's overly restrictive. But specifically the ISM rules or the in-kind support and maintenance, Social Security policies and public, those rules, they change all the time. There's just been a huge update to how we run that and what counts as in-kind support and maintenance. Years ago, when I first started practicing, it was Social Security had to be used to pay for food, clothing, and shelter. Food, clothes, and shelter, right? You didn't want to pay for any of those 3 items out of a special needs trust. Then clothing dropped off so that a special needs trust could pay for clothing without any reduction of income or SSI benefits to an individual. Then food came off. And so that was a huge benefit to people with disabilities, so that a trust could pay for food for someone without reducing their Social Security benefit. So trusts and trustees and understanding the complexities of these rules and how to maximize benefits and yet pay for things in a special needs trust, it's huge, right? And this is where the benefit of a professional trustee who is supposed to know all of these rules is really, really helpful to the family, but most importantly, the beneficiary. One of the huge advantages to using and knowing about an ABLE account is that when you're administering a special needs trust, it's not so much what you pay for, but how you pay for it. So if someone needs rental assistance or housing assistance, where they want to be in a higher, let's say a higher standard of living than what's affordable to them under SSI, how does a trust pay for that? Well, if the money comes directly from a trust, then it reduces their SSI. And so if it can be utilized where the trustee can place money or distribute funds to an ABLE account instead, the beneficiary can make up for the shortfall between their income and the rental obligation or their basic needs between like utilities or an HOA. They can pay for that shortfall using an ABLE account without reducing their benefits. So these are the tips and tricks that a professional that is the benefit of knowing intricately how the public benefits interact with a special needs trust to maximize what's available to that beneficiary. Number 2 is really opting for guardianship. So again, this is about special needs planning in general. And so this is one of the biggest mistakes I see all the time, which is that parents are opting for guardianship when a power of attorney will suffice. So we have a whole YouTube video that's an hour that's just about this topic. And I will say that just generally, there's what we call institutional bias. Facilities, school systems, people in general, they prefer to see a court order with a seal. They prefer guardianship, where that might be too restrictive and the individual. We are always trying to promote the individual having agency, having authority to make decisions as much as they can to promote independence. And so always the first option should be the least restrictive, which is a power of attorney. Is that appropriate in all situations? No, of course not. Absolutely not. But there is an institutional bias where the school systems and school districts automatically start preparing the families for guardianship. And so this is where we should push back on that. We want to make sure that we are opting for the least restrictive, most appropriate means to help an individual. Like I said, there's a whole YouTube video just on power of attorney versus guardianship. Top mistake that I see is not testing the plan. And this is where a special needs plan, a good special needs plan, is really about way more than just the document. We've spent so much time today just talking about the intersection of public benefits, but it is not just about the document. It is about accessing and balancing public and private resources, maximizing the independence of that individual and promoting them to reach their maximum potential. To be a vital part of the community and having meaningful life. And so one of the most important things that we can do is not just set it and forget it. And so when you have a special needs plan, particularly on the estate planning side, it's really the intersection of all of these professionals and testing the plan. What will it take if you were gone for an hour? What would it look like if you were gone for a whole day, a weekend, a week, 2 weeks, a month, 3 months, or forever? What would you have to test and try in order to be comfortable, in order to know that you've done all that you can to make sure that your loved one is going to be protected, maximizing their independence, growing, and thriving, even without you here? And it is incredibly essential that you test the plan that you have put in place. And it takes years to develop this over time. Because wouldn't you rather know something doesn't work while you are here and able to adjust? Yes. And so that is the biggest mistake that I see parents make, is that they tend to become isolated. They are used to fighting the good fight, right? But also very, very protective, where everything is taken care of in their own home. And I would say that you absolutely should test what happens when you're not here or unable to take care of your loved one. And that could happen through your own aging process, an accident, illness, or injury. And having those things that are not just put in place, but actually tried is incredibly important. And so with that, thank you for your time and attention. And again, if there's a topic that occurs to you that you'd like us to do a deeper dive into, please just leave it in the chat or connect with us and say, hey, Michelle, talk about this, because we'd love to hear more from you about what you're interested in hearing more about. And so thank you for your time and attention today. And I hope you learned a lot.